My lord, it is covered by your lordship's judgment in the case of this Mallikarjuna Shipping Private Limited. ಮೊದಲು ಪಾರ್ಡನ್ ಮಾಡಬೇಕು. ಇವರು ಹಾಗಲ್ಲ. I will wait. I will direct the magistrate to record your statement under 164. I will look into the 164 statement. Then I will consider the issue whether I should give you the pardon or not. That is impermissible under law.
Allah, yaar, who has sought pardon now?
A1, first accused in the case. My lord, more than that.
So why are you aggrieved by that?
My lord, against me.
You are accused number 15.
I am 15. The prosecution wants the first accused to be treated as an approver so that he could give evidence against me. ಇನ್ನೊಂದಿದೆ ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ, ಒಂದು ಲೀಗಲ್ ಇಶ್ಯೂ ಹೇಳ್ಬಿಡ್ತೀನಿ ನಾನು ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ. ಅಲ್ಲ, ಟ್ರಯಲ್ ಈಸ್ ಗೋಯಿಂಗ್ ಆನ್, ಎವಿಡೆನ್ಸ್ ಈಸ್ ಬೀಂಗ್ ರೆಕಾರ್ಡೆಡ್. ಬಟ್ 164 CRPC comes into play not subsequent to the commencement of the trial. Kindly have a look at section 164, which comes on to chapter 12. Yes. Only during investigation, my lord.
Correct.
ಅಷ್ಟೇ. ಇವರು ಟ್ರಯಲ್ ಆಗುವಾಗ he assumes the role of an investigator, the judge. No, I want his 160. It is not the prosecution that is seeking for.
He is recording the statement of the approver.
My lord?
Is he recording the statement of the approver?
No. How can he do it, my lord? My lord, he should be only a presiding judge and not a participating judge. I am sorry to say this. How could he ask the magistrate to record his 164 statement and send it to him? ಆ ಸ್ಟೇಜ್ ಮುಗಿದೋಗಿದೆ. Only during investigation 164 could be recorded. Have a look at the language of section 164, my lord, for a second. Would your lordship permit me to take your lordship to 164? It comes under chapter 12, investigation, commencing from 154.
But someone's issue a copy ಕೊಟ್ರೆ 11th never ಮಾಡಕ್ಕಾಗಲ್ಲ.
Copy ಕೊಟ್ಟರೆ the day before yesterday. ಈ ಫೈಲ್ ಕೂಡ ಈಚೆ ಬರಲಿಲ್ಲ.
Could have been uploaded on the same day.
ಅಪ್ಲೋಡ್ ಮಾಡಿಲ್ಲ. I am sorry, it is incorrect. 10th night ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೂ ಒಂದು ಹೇಳ್ತೀನಿ ಬೇಕಾದ್ರೆ ನಾನು ನಿಮಗೆ. ಇದರಲ್ಲಿ I have not come across a case where in the order, my lord, the learned judge writes, I have dictated this order between 1 PM and 2 PM ಅಂತ. ಅವತ್ತು ನಾವುಗಳೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಇದ್ರು. ಅವರು 10 ನಿಮಿಷದಲ್ಲಿ ಆರ್ಡರ್ ಮುಗಿದೋಯ್ತು. ಆರ್ಡರ್ ನಲ್ಲಿ ಬರುತ್ತೆ ಅದು ಬಿಟ್ವೀನ್ 1 PM and ಅದು ಅವಶ್ಯಕತೆ ಏನಿತ್ತು ಹೇಳಿ, ದಯಮಾಡಿ ಹೇಳಿ ಮಿಸ್ಟರ್ ಪ್ರಸನ್ನ ಕುಮಾರ್.
ಏನಿತ್ತು ಅಂತ ಬಹಳ ಹೇಳ್ಬೇಕಾಗತ್ತೆ, ಬೇಡ
ಹೇಳೋಣ. Subject to the condition that once pardoned, he should make a full and true disclosure of all of the circumstances within his knowledge to the court concerning the issue. ಇವ್ರ ಆತರ ಅಲ್ಲ. He is putting the cart before the horse.
Now pardon is already made.
But
he has already pardoned him.
Yes. No.
Order is not passed.
No. After 164 statement.
No, 306 order is not passed.
No order is passed.
No, sir.
Order is passed on the application filed under section 306 after getting his 164 statement recorded.
Now, dehorse this statement. He could have accepted him becoming an approver.
That's it. He could have rejected or accepted it.
He has accepted it.
No. After recording the statement.
It's all right. Now he has recorded the statement and accepted it.
He did not record. He would direct the magistrate to record.
All right. Recorded statement is recorded.
Scope ilvalla record ಮಾಡೋದಕ್ಕೆ ಎಲ್ಲಿದೆ?
Even otherwise, without dehorse this also, he could have passed an order accepting him.
The earlier application came to be rejected on the same ground.
That will consider.
But because of the change of guard in the court, the application filed. Came to be filed.
Now what I'm telling is, without this statement or with this statement, the concerned court was empowered to pass an order accepting.
No, not on a bald application. That is what the Supreme Court has said.
Accepting or rejecting the application under 306.
Under section.
That will be tested on that. Even if this is not in existence, 306 can be agitated.
But on 13th of March 2023, an application came to be filed by the first accused in the case, invoking the jurisdiction of the court under section 306 of the CRPC to permit him to be treated as an approver in the case.
All right.
On 13/3/2023. And on 29th of April 2023, that application came to be rejected by the trial court. Well, may I just request your lordship for a second to have a look at page 146.
No, now what is called, why 230 urgency ಏನು?
ಹೌದು, ಅರ್ಜೆಂಟ್ ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ ಎವಿಡೆನ್ಸ್ಗೆ ಅಂತ. ಅವಂದು ಅಪ್ರೂವರ್ ಎವಿಡೆನ್ಸ್ಗೆ
ನಾಳೆಗೆ ಹಾಕೊಂಡಿದ್ದು ಯಾವತ್ತು?
ನಾಳೆಗಿದೆ.
ಅಲ್ಲ, ಯಾವತ್ತು ಹಾಕೊಂಡಿದ್ರು ನಾಳೆಗೆ?
30ನೇ ತಾರೀಕು.
5th.
30ನೇ ತಾರೀಕು. 30th not is order.
ಅರೆ, ಈ ಆರ್ಡರ್ ಮಾಡಿರೋದನ್ನೇ 12ನೇ ತಾರೀಕು. ಅದಂಗ ಅವತ್ತು ಹಾಕೋತಾರೆ
ಸರ್?
30ನೇ ತಾರೀಕು ಆರ್ಡರ್ ಮಾಡೋದು.
ಅಕ್ಟೋಬರ್.
ಸಮನ್ಸ್ ಮಾಡೋದು 5ನೇ ತಾರೀಕು. ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟರೋದು 11ನೇ ತಾರೀಕು, ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ.
164, yes, sir.
Yes, my lord. Any metropolitan magistrate or a judicial magistrate may, whether or not he has jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter. ಎಲ್ಲಿದೆ ಟ್ರಯಲ್ ನಡೆಯುವಾಗ 164 ಮಾಡಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ. That too, not at the instance of the IO. The learned judge says.
Where is the order?
Yes, my lord. May I request your lordship to kindly turn to page 47.
Allah, ಈಗ 90 page, I am seeing, where is it?
No, page 47. Kindly go.
47.
7.
ನಾವು ಅಪ್ರೂವರ್ ಆಗಿ ಅಲೋ ಮಾಡಿ ಆಗೋಗಿದೆ 306.
ಈಗ ಅದನ್ನ ಆರ್ಡರ್, that is the one which we have questioned now.
He could not be turned as approver.
Yes, he can't be treated as an approver so that he could give evidence against me.
Now, who is accused number 1? That petition ಯಾವುದು ಮುಟ್ಟಗಿ.
ಮುತ್ತಗಿ.
ಸರಿ. Because I have dismissed this case as accused number 1. Yes.
But kindly have a look at page 337.
337.
337.
ಅಲ್ಲ 47 ಅಂತ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲ ಅದು ಬೇಡ. ಅದಕ್ಕೂ ಮುಂಚೆ ಆರ್ಡರು ನೋ I will ask the magistrate to record your statement under 164. If you side with the prosecution, then I will give you the permission for being treated as an approver. Anta. Unheard of. But it is always the prosecution or the investigator who is indeed entitled to make an application under section 306. An accused can't ask. That is the law laid down by the Supreme Court. But have a look at section 300.
ಅಲ್ಲ ಈಗ 6 ಗಂಟೆಲಿ ತೀರ್ಮಾನ ಮಾಡಬಲ್ಲ, ನಾಡಿದ್ದು ಮಾಡೋಣ.
ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದು ಬೇಡ, ಬೇರೆ ಎಲ್ಲ ಮಾಡಿ. ಓನ್ಲಿ ಅವನದು ಎವಿಡೆನ್ಸ್ ಬೇಡ ಅಂತ ಅಷ್ಟೇ.
ಯಾವುದು ಎವಿಡೆನ್ಸ್ ಆಫ್ ದಟ್ ಮುಟ್ಟಗಿ, ಅದನ್ನ ಆಮೇಲೆ ಮಾಡಿ.
Your lordships have already held, not in 2023, the co-accused not will have no legal right challenge not the order of pardon granted to another. This is not I just pass.
That is a Yogeshwar case.
No, ಇದರಲ್ಲಿ ಇನ್ನೊಂದು
ಇದೇ ಯೋಗೇಶ್ವರ್ ಕೇಸ್.
ಮಲ್ಲಿಕಾರ್ಜುನ shipping, not para 10. At page 204.
ಅದ ಮೊದಲು ಪಾರ್ಡನ್ ಆಗ್ಬೇಕು, ಆಮೇಲೆ ಎವಿಡೆನ್ಸ್. ಇವ್ರು ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಪಾರ್ಡನ್ ಮಾಡ್ತೀನಿ ಅಂತ.
ನಿಮ್ಗೆ ಅದರ ಚಾಲೆಂಜ್ ಮಾಡೋದಕ್ಕೆ ರೈಟ್ ಇದೆಯಾ ಅಂತ.
ಅದು ಸರಿ.
Apex Court was pleased to consider it, not which your lordship not after following the judgment of the Apex Court, not at para 10.
All right, we'll 6 o'clock ಆಗಿದೆ, we'll hear it.
Not order is passed not on 30th October.
On a particular day, 20th or something.
Any day, my lord. ಅಲ್ಲ ಈ ಕೇಸ್ ನಲ್ಲಿ ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿದಿರಿ ಇಲ್ಲಿ. ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 8 my lord. ಸೇಮ್ ಕೇಸ್. ಕೈಂಡ್ಲಿ ಗೋ ಟು ಪೇಜ್ 8.
8 of
ಈಗ ಅವ್ರ ಪ್ರಸನ್ನ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು
ಅದರಲ್ಲೇ
ಪೇಜ್ 8. ಪ್ಯಾರಾ ಇಲ್ಲ ಇಲ್ಲಿ. ಪೇಜ್ 8 ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 306 ಟೆಂಡರ್ ಆಫ್ ಪಾರ್ಡನ್ ಟು ಎನ್ ಅಕಾಂಪ್ಲಿಸ್. My lord gets it, my lord? Now kindly go to the next page. Section 306 mandates concerned court to accept an application filed seeking tender of pardon to any accomplice in the crime.
Now, where is the order under 306 now?
Yes, my lord. It is
Page 47.
Yes, page
The
47.
operative
That is
portion
what
is
I
at page 91.
Application filed by Muttagi 306 CRPC is hereby allowed and is considered to be an approver. What's wrong?
ಎವಿಡೆನ್ಸ್ಗೆ ಅವನ್ ಸಮನ್ ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ, ಈಗ anybody can turn approver.
Anybody can turn approval, my lord. He places reliance on the 164 statement which you would get recorded by the magistrate.
Where is that?
Yes, my lord. He refers to it in the order itself, very order itself.
Where was the direction to the magistrate? To
yes, that is exactly what I said. 338. Kindly go to 338. Then I wanted your lordship to have a look at 337. No, my lord. It is uncertain. What the Supreme Court would say is, have a look at the earlier order which came to be passed by the very court at page 124. Kindly go to 142. Kindly go to 142. Kindly permit me to take your lordship. This is earlier application. I have gone through section 306, 307, 308 CRPC. There is no bar, as my lord has pointed out, there is no bar either under section 306, 307 CRPC to tender pardon to an accomplice, and court can tender pardon at any stage of the investigation or inquiry into or trial of the office. Now, in this case, a charge is not yet framed, At this stage, the accused number one has filed an application under section 306 CRPC seeking tender of pardon from this court. In the application filed by the accused number one, he stated that he is ready to give tender. He is ready to give tender of pardon in support.
Now, you need not dub that as 164 statement. On what basis will he become an approver? He should give some statement that yes.
Yes, my lord, he must at least set out in the application what really happened, what is the role played by him, what is the role played by the other persons, without which how does he tender? That is what the learned judge would write here on the earlier application. Same carbon copy application is filed now. I produced both the applications. Earlier application, kindly go to page 144, para 19.
We'll hear it. Not at this hour, but 20ನೇ ತಾರೀಕು 21ಕ್ಕೆ ಹಾಕ್ತೀನಿ. Let the court not record his statement.
That's all.
Chief, we will examine not his chief examination.
Oh. If this order goes, it can't be a witness.
Recording of this person's statement will be deferred.
Yes.
ಬೇರೆ ಎಲ್ಲ ನಡೀತಾರೆ.
Madli.
Evidence ಇದೆ. Now, there's already direction by this honorable court. The trial should conclude with him, not 3.
ಅಂದ್ರೆ ನೀವು ತಪ್ಪು order ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ನಾವು ಸುಮ್ಮನೆ ಇರಬೇಕು ಅಂತನಾ?
No, first of all, you have no right of audience that I have brought you.
That is
they should show not how they have right of audience. Right of audience, till they may not now they are saying not that.
ಇವ್ರದೇ ಒಂದು 482 dismiss ನಾಗೇಂದ್ರ ನಾಯಕ್ appear. Yes. All right. Right of audience illa ಅಂತ 306 they cannot challenge.
That's what your lordship not have held. Your lordship.
We are the persons who are affected.
ನಗೋದೇನಿದೆ ಅದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ರೆ ತಾವು ಹೇಳಿದಿರಾ?
Who else could challenge it?
Could challenge it, my lords. Co-accused if they can't challenge.
Have I written that it cannot be challenged?
No, it only starts like that, my lords. My lords has not
Ma'am,
given a
not
finding on
2013
that.
Supreme
Draft
Court.
notice.
2013.
Have I said?
Finally.
Allah, have I said the accused have no locus to challenge?
No, my lords.
May I just not?
This is how my lords.
2013 not my just.
Paragraph
2013-15 Supreme SEC.
Allah, irli ನನ್ನ order ನೋಡ್ಬಿಟ್ಟು.
Tavidun this may not your lordship not have said.
I've got.
Para 40 of not this SEC.
It just starts, my lords, whether and no, my lords doesn't give a finding on that. Paragraph 10, the starting point, and then thereafter it may be noticed, my lords.
ಯಾವ ಕೇಸಲ್ಲಿ ಸರ್?
My lords, this was in that Mallikarjun Shipping Private Limited.
In the light of the aforesaid judgment parallel statute.
Paragraph 10.
This kindly come to me not 2013
Pardon is
not para
permissible
40.
exercise of power concerned so and so permitted. Judgment relied on.
So many decisions of the Supreme Court.
Paragraph
my lords,
40.
Only be the co-accused.
But the
paragraph
crux of this.
Will challenge it, my lords.
Not para 40 not of this 2013 Supreme Court.
And my lords.
That is Ashok Kumar Agarwal.
Please, ma'am.
My
Para
lords, may
40.
I just add one aspect, my lords. Virtually the same application.
Carbon
same
copy.
statement filed by CBI.
ಅಲ್ಲ ನಿಮ್ಗೆ ಗ್ರೀವೆನ್ಸ್ ಇದೆ ಹೇಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ. ಅಲ್ಲ ಅವರೊಂದು ಪ್ರಶ್ನೆ ಹೇಳ್ತಾರೆ ಉತ್ತರ ಹೇಳಕ್ಕಾರ ಬಿಡ್ಬೇಕಲ್ಲ.
ಎಲ್ಲರೂ ಸರಿ 6 ಗಂಟೆಯಲ್ಲಿ ಏನಿದೆ?
ಅಲ್ಲ ಅವ್ರು ಆರ್ಡರ್ ಆದಾಗ ಮೂವ್ ಮಾಡಬೇಕು. ನಾಳೆ 5 ಗಂಟೆ ಹಿಂದಿನ ದಿನ ಬರ್ತಾರೆ 2:30 ಕೇಳ್ತಾರೆ.
When the trial is going on, why is there
other witnesses are there?
Other witnesses are there.
Summons are there.
ನೀವು ಹೇಳಿದಾಗ ನಾವು ಟ್ರಯಲ್ ನಡೆಸೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನೋಡಿ they are agreed by not let them come on time. Not when it is listed.
On time ಅಂದ್ರೆ 12ನೇ ತಾರೀಕು ಕಾಪಿ ಕೊಟ್ಬಿಟ್ರೆ ಇವತ್ತು 13. ಇನ್ಯಾವ ಬರ್ಬೇಕು ನಾನು? ಅದು ಬೆಳಗ್ಗೆ 10 ಮೂವ್ ಮಾಡಿದ್ದೀನಿ.
Yes.
My lord was so considerate to get this matter listed by issuing a direction to the registry.
Not my submission is.
ಇನ್ಯಾವ ಬರ್ಬೇಕಾಗಿತ್ತು
My
ನಾನು?
submission 2013 Supreme Court kindly have a look at paragraph number 40. So far as entertainment of the case at the behest of the respondent by the High Court is concerned, we may state that he may not have a legal right to raise any grievance, particularly in view of the law laid down by this court in so and so. However, the revisional powers under section 397 read with 401 can be exercised by the court suo moto, particularly to examine the correctness and authority of any finding, sentence or order.
Your evidence
so regularity
is being laid against
of any
me.
proceedings of the inferior.
The revisional court powers can be exercised, but
In
ಅವ್ರಿಗಿಲ್ಲ. This is what Apex Court has said. They have no right.
so, not by them. So moto revisional powers can be exercised. And 482 can't be exercised. Yes. Reddy has a lot to say.
Please.
Yes. ಯಾವತ್ 20ಕ್ಕೆ ಹಾಕೋಣವಾ? 20ಕ್ಕೆ ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ 2:30ಗೆ ಮೇಡಮ್ ದಟ್
22nd
ಎಲೆಕ್ಟ್ರಲ್ ಬಾಂಡ್ಸ್ 28 ಹಾಕಿ 20 ತಾನೇ ಹಾಕಿದ್ರು 21st ಹಾಕೋಣ
22nd.
22nd.
Second.
22nd.
Please.
22nd 2:30. Yes, because ಇದು ಅಲ್ಲಲ್ಲೇ ಮುಗಿದೋಗ್ಬೇಕು.
Please.
This can't hold on the trial. Yes. Heard the learned. ನೀವು ಹೇಳ್ತೀರಾ ಕೋರ್ಟ್ಗೆ ನಾಳೆ
ಅಲ್ಲ ಸ್ವಲ್ಪ
ಇದು
ಕಷ್ಟ.
ಅಪ್ಲೋಡ್ ಮಾಡೋದೆಲ್ಲ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಇಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ, ನೆಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಡಿಕ್ಟೇಟ್ 2 lines order not I.
ಮೇಡಮ್ ಇದು ಅಪ್ಲೋಡ್ ಮಾಡಕ್ ಮಾತ್ರ ಮಾಡಿ ಡೀಟೇಲ್ ಆರ್ಡರ್ ವಿಲ್ ಪಾಸ್. ದಿ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ shall defer recording the evidence, either recording the evidence of
The first accused as the approver in the
the accused number 1 who has now turned approver till further orders at the hands of this court.
Please.
List the matter on 22nd at 2:30 p.m.
Please.
All right.
Till further orders ಅಂದ್ರೆ ಮತ್ತೆ ಆಮೇಲೆ
ಅಲ್ಲ,
ಪಿಟಿಷನ್ ಮುಗಿದಿದೆ.
till the next date of hearing. Further orders and next date. All right. Till the next date of hearing. It's too late now to pass an order.
We will be inhuman, my lord, if we
All right.